So the highly anticipated federal government bail changes have been announced today, and they are a big ol' nothing burger. Basically what we're looking at is adding a few more reverse onuses, which in practicality is not going to change anything. What a reverse onus means, and it sounds like it makes it harder to get bail, but all it means is that the person who is asking to be released on bail has to demonstrate why they should be released, instead of the Crown having to demonstrate why they should be detained. The considerations that the judge is applying are the same. They're looking at the primary, secondary, and tertiary grounds for whether somebody's going to be released. The other thing that we see in this legislation that is completely unnecessary are provisions that are going to require judges to consider the credibility and reliability of a bail plan. A bail plan is essentially what you would present to a judge saying, this is the plan for what's going to happen if I'm released. These are the conditions I propose. This is where you could release me to. This is my surety. All those types of things. The judge is going to have to consider whether that's a good plan. That's what judges are already doing. And the bail legislation also says that a judge must consider whether or not it would be a public safety risk to release somebody, which is already one of the grounds that judges consider in determining whether to grant bail. It is already part of those primary, secondary, tertiary ground considerations. All this is a codification of existing bail law that essentially is designed to appease the public by making them think that bail is going to be tougher to get, but really it's just saying what's already happening to people who don't understand what's already happening. Is it going to be resulting in more people being denied bail? Probably not. Because if you have a good bail plan, even if the onus is on you, you're still going to be able to demonstrate why you should be released. And when it comes to these provisions that are supposed to make it tougher to get bail, it completely neglects the fact that the Charter guarantees a right to reasonable bail. The Supreme Court of Canada has ruled already multiple times that you can't start from the presumption of denying somebody bail, but consider all the lesser restrictive options before determining that somebody needs to be detained. And in this bill, the government is trying to address that by creating a provision that essentially says that this restraint principle, and that's what the principle is that says this restraint principle doesn't function to create automatic release. There's never been automatic release. It's not like you get charged with a first-time assault, you go before the court, it's just rubber stamp, you're out. You might be charged with assault and go before the court as a first-time offender and have an easy time getting out because you have good community connections, no criminal history, no grounds that would make it a risk to release you to the public, no big public concern about your conduct that would justify you remaining in custody, no concerns that you're not going to show up to court or participate in the proceedings or you're going to flee the jurisdiction, right? Those are the things judges are looking at. And so lots of people are effectively automatically released because the application of the law results in that. This statement in the bill that the restraint principle doesn't mean automatic release, again, changes absolutely nothing. All of this is really just performative legislation to try and acquiesce a public who doesn't understand how bail systems work, who doesn't understand the considerations that judges have, and who've never seen a bail hearing in their lives. This is just writing down the rules that are already applied.